directors, which is oversee the management of the administration of the business and affairs of the cooperative. And that's actually in the legislation. And as you can see, management of the administration of business and affairs of the co-op could include almost anything, and it includes almost everything. And for the most part, practically, what this includes for the board is overseeing the co-op finances on a regular basis, planning for future needs, making any major fundraising or capitalizing decisions, maintaining property and assets on behalf of the cooperative, member relations and communications, hiring staff, et cetera, et cetera. And these types of decisions look quite different in different types of co-op sectors. So, maintaining the property and assets of a housing cooperative is going to be a much different sort of situation, a very important function for the board, whereas it might not be in a very small cooperative that doesn't own any property or major equipment. So it's important to know that some of this will change and will be dependent from sector to sector. And so, what does this look like in terms of the types of decisions that the board is making? The regular decisions that the board is making are approval and termination of members. And we get asked this question a lot. A lot of people are saying, how can we preserve the member character of our cooperative? What if somebody, there is no situation where a member is just coming in, dropping their fee, and you absolutely have to accept them as members. There is an approval and a termination process that allows the board to, on behalf of the members, maintain the proper member character of that cooperative to make sure that the member needs as a whole are being met. And so this is a very important function of the board. It's not necessarily just a rubber stamp of approving every member that comes through the door. Other key functions that the board is making on a regular basis, usually on a yearly basis, are the declaration of dividends and interest payments and the declaration of any patronage payments that are going to go out. They also need to call the annual general meeting on a yearly basis and any member meetings that are going to be held in addition to the annual general meeting. From a human resources perspective, making decisions around employment and performance review and any termination that may be required of the senior employee in a cooperative, and regular review and approval of financial statements and any decisions required around legal matters that face the cooperative. And so these are all mandated by the legislation that the board is responsible for these decisions. Now, Joy's question was around, what about the vision, the mission, and the values of a cooperative? Once those have been passed, do they need to go back to the membership? And the legislation is silent on that. From the legislation's perspective, because it doesn't involve money or lawsuits, there's really no need to legislate it. The mission and vision is not quite irrelevant from a legislation perspective, but almost. So this is more of a best practices sort of thing. There's certainly no requirement for the board to go back to the membership to have them decide on a new mission or a vision or a strategy, but it would be a very interesting case to try and have the board make that decision on behalf of a membership. I don't know of any cooperatives that don't go back to the membership to have mission and vision at least received and approved by the membership. The membership may have limited input in some cases due to practical concerns, getting input from everybody in a way that's meaningful for that process around changing mission or changing strategy can be quite challenging. But certainly I would recommend that in terms of maintaining the cohesion within the cooperative and the members understanding what they're there for, it's very important that they see any sort of proposed changes to the mission and vision, even if it's not legislatively mandated, that they do go back to the membership. So I would argue that from a best practices function, it would be, if not required, then very strongly recommended. And I'm not sure if that's the same in other jurisdictions or not. I would hazard a guess that it's not. Legislation usually restricts itself to issues around money, property, and tangible sorts of things, rather than mission and vision, even though they are critically important to the functioning of a cooperative. So you may be thinking, okay, well, that's a lot of responsibility for a board to take on, and it is. And this is why it's important for directors to act in good faith. And the concept of good faith is one where when the board of directors comes together at a meeting to make decisions on behalf of the cooperative, that they do so honestly, and that they do so with the best interests of the cooperative in mind. So they're sitting at that table making decisions on behalf of the cooperative and therefore on behalf of the membership, and so they have to be viewing those decisions with the best interests of the co-op in mind. And they also have to adhere to what is often referred to in legal terms as a standard of care or a duty of care. And that's a legal framework that requires that when a director is making decisions or when the board is making decisions around issues that affect the cooperative, that they need to act as a reasonably prudent person would. And so what this means is that, if you want to make a decision around a contract that you're going to use, say, to hire a consultant or something like that, you don't need to be a lawyer to review a legal contract. But it also means that you need to ask yourself, well, would a reasonable person pass this without running it by their lawyer, or would a reasonable person not read this contract before passing it? So it's meant to sort of enforce common sense. Voltaire is attributed with this quote, but I don't think he actually said it, but common sense is not so common, and that's where the legislation sort of kicks in and says, well, here's your framework, and it's this idea of standard of care. And this is where the importance around conflict of interest for directors comes in. And if these directors are supposed to be acting in the best interest of the co-op in mind, there may be situations that come up where their personal interests are at stake and may conflict with their role as director to make decisions on behalf of the cooperative. And this can be a very tricky situation. And we'll talk about conflict of interest on the next slide. But important to know that in Ontario, and this is a relatively recent change to the legislation to bring it in line with other corporations, is that co-ops can protect their directors and their decision-making responsibilities through what's called an indemnity policy. And what this says is if directors are acting in good faith and they weren't negligent and they were adhering to a standard of care, and something bad happens as a result of a decision that the directors may have made, the co-op can cover the costs of the financial consequences of that decision, as opposed to having the directors do it themselves personally. And so this is an important way that the co-op can free up the directors to feel that they can make decisions without feeling like they, or without being worried about them serving on the board because they're worried about the impacts of their decisions. And also directors and officers liability insurance can assist with this as well, in terms of, again, all bets are off if directors are negligent in their decision-making duties, or they're not acting in good faith, or there's a conflict of interest situation arising. Then there's no guarantee that the indemnity clause will protect directors and cover the costs, or that directors and officers liability insurance will help. So that's an important role that the directors fill. It can be quite scary for new directors, especially those that haven't had a governance experience before. But the idea is that there is a framework there to protect you in terms of your decision making. And it doesn't mean that you can't ever make a mistake as a director. Everybody makes a decision where if you had to go back and do it over again, you would make a different decision had you known what the outcome was going to be. What it means is, when you're making that decision, you have to be following good faith and adhering to that standard of care. So let's talk a bit about conflict of interest. Conflict of interest, which I've abbreviated here to COI, can be really tricky. So I've got an example here. Which of the following examples would not be considered conflict of interest? And the first is the co-op wants to grant a contract for all of its yearly printing services, so that would be a fairly significant contract, to one of three companies, and one of the directors on the board also happens to be president of one of those companies. The second scenario would be the co-op decides to grant a service contract to a company where a director is the president of that company, and they don't ask for other bids from the membership, or the co-op is considering making its board meetings standard on Tuesday evenings, which conflicts with one of the director's yoga classes. And so, as you can probably guess, the third situation is not a conflict of interest. Although it's certainly inconvenient for that director, it's not a true conflict of interest. And conflict of interest from a legal perspective usually means that there's money involved, or that it's an opportunity that isn't available to everybody. So you're providing preferential treatment to one member or director of the cooperative at the expense of others, or there's going to be financial benefit involved. In some cases, cooperatives will err on the side of caution and have directors declare conflict of interest even if there's no money involved, but there might be issues around what is often called the perception of impropriety. So it looks like somebody couldn't make a decision honestly because, their opinion was involved in some way, even if money wasn't changing hands. Some co-ops will indicate that can qualify as a conflict of interest. Legally, though, it is usually restricted to these cases where it's money or material issues. And so a lot of this comes down to, is this issue that I'm faced with as a director around conflict of interest important enough that a reasonable person would want me to disclose it? And in the case of, if we're talking about granting a fairly significant printing contract to someone, I would want to disclose that there was a director on the board that if the board was responsible for that decision, you'd want to disclose that someone had a personal interest in that. And, it doesn't mean that you're not capable of keeping two sets of interests in your mind, but it does, there is the perception that your personal interest could cloud or impact your ability to make positive decisions on behalf of the cooperative. And so how do you deal with conflict of interest? When there is a conflict of interest, it's the director's responsibility to declare that they're in a conflict. And they say, I'm president of this one of the companies that's voting on this, or I'm in conflict because my partner or my spouse is involved in this, or you're talking about hiring my child. So sometimes it's very clear, and it's the director's responsibility to declare the conflict. However, if the director that's actually in the conflict doesn't declare, but somebody else around the board of directors table knows that there's a conflict that exists, they should declare it, even if the person actually in conflict doesn't declare it. And it has to be declared at the meeting where it's brought up, or it has to be done in writing ahead of time. So, if as directors you get an agenda in advance of the meeting and you see that, and you get the material ahead of time that indicates that you're going to be in a conflict, you should indicate that in writing before the meeting that you're going to be in conflict, or make sure that you bring it up at the meeting. And it needs to go in the minutes when conflict of interest is declared. And the critical part is if you declare as a director that you're in conflict of interest, you absolutely cannot vote on the issue. And although it's not required by the legislation, best practice and certainly prudence would indicate that person should leave the room or not be involved in the discussion in order so that there's, again, around this idea of appearance of impropriety. You don't want any sort of stain attached to the decision that actually gets made, and for the director to remove themselves from the room, removes the possible accusation that they could have tainted the discussion just by being there. And so that's not required, but it certainly is best practice that if you declare conflict, you don't vote, and that you leave the room. And this doesn't affect the quorum. So when you have a board meeting, you are required to have your minimum number of directors there in order to have it considered a proper board meeting. And you can define that to be any number that you like. The cooperative can define that quorum in their bylaws as long as it's not lower than 2/5 of the number of directors. And so if one of the directors has to leave because of conflict of interest, this doesn't actually affect the quorum. So that's important to know so that you don't feel that that director has to be there in order for you to have enough directors around the table to actually make the decision.